Good morning, everybody, and welcome to The Breakfast Show.
BBC Three Counties Radio.
A Watford woman is furious at her treatment by a judge at a Watford County Court. She accompanied a friend who has dementia and had hoped to speak on his behalf. Despite writing to the court in advance, she was thrown out by the judge and not allowed to stay with him during the case. Now, Sandra Kira-Kidez joins me on the line now. Good morning to you.
Good morning, Andy.
Thank you for joining us this morning. What was the case about?
I can say my friend has a property in Watford. It's in a cul-de-sac, and there are 12 leasehold maisonettes in 3 blocks of 4. The rest of the buildings are freehold houses. The freehold is with a company called Consolidated Properties, and they have managing agents, Lawton, Pryor and Mecklenburg in Watford. Both properties are rented out. In December 2015, water was seeping into the bedroom of the first floor maisonette, which is owned by my friend, and it was causing damage to the property of the tenants. So I contacted a professional roofing repair contractor who I'd known for years and who's done a couple of jobs for me before to have a look at it. And he said the guttering and soffits were completely rotten and needed replacing, and water was getting under the soffits and into the wall. And he said it couldn't be repaired as the condition was too bad to join anything to what was there. The lease says that work has to be through the managing agent. So I contacted them and they said they'd either handle it and recharge the cost to Maisonettes 1 and 2, or we could go ahead with an approved contractor, and the latter would be much quicker and cost much less. So at the time it was explained that the costs of repairs should be shared between either 2 or 4 properties, depending on where the issue lay. And in this case, it was just over 1 and 2. So as the problem was urgent, and it was just before Christmas, instructed the contractor to go ahead immediately. And the weather was really wet this was December 2015. It poured all the time. I was dealing with everything on behalf of my friend and had never lived in a property. So inadvertently, I failed to notify the owner of the ground floor person.
Sandra, it sounds a very complicated kind of. So you had to go to. Obviously, it ended up going to court.
In the end, we had to go to court because the owner of the ground floor wouldn't mediate.
Okay, so you had to go to court, and your friend has dementia, so you wanted to speak on their behalf, yeah, and you wrote in advance.
Right. I'd written to the judge. Yeah. And I'd said that I'd been the person who's liaised on behalf, and this was at the suggestion of the solicitor and of the court people I spoke to after mediation.
Okay, so
they write to the judge in advance. So I handed the letter in with the court papers, which was in February, way before the case, and explained why I was doing everything, and that he had mild dementia, but it just meant that he couldn't cope with paperwork or grasp things very quickly. And
okay, so far, just ticking the boxes here. You've taken advice from a solicitor. You've taken advice from the court. You've written the letters. You've done it all. You haven't just rocked up on the day. You've given fair warning. You're there.
Yeah.
What happened then in front of the judge?
Okay, so go in the room. The judge says, no, you can't sit there next to him. Go and sit over there at the back of the room. And she then introduces herself and explains what's going to happen and asks my name. I tell her. And she then says, I'm not going to speak to you. I'm not able to speak to you. I said, well, I've written a letter explaining. She said she doesn't read letters. They don't read email. And it wasn't even her who I'd written to. I'd written to the senior judge. But somebody must have opened the letter. Somebody must have passed it on to someone. And I know they had it because I handed it in person with the papers, and she didn't seem to have even read the papers properly. But I heard her before I left the room, which she threw me out and wouldn't let me do anything. He doesn't remember anything of what was said.
Okay, it all sounds very, very, very odd as well. So let's get some advice on this. Let's talk to Jaffar Shah, who's from the Bedford-based company Deo Volente Solicitors. Thank you very much for joining us this morning. Does Sandra have a right to be annoyed here?
Yeah, good morning, Andy. I'm very saddened to hear the experience that Sandra has gone through in relation to this particular case. From a legal perspective, the reality of the situation is this. A letter was written to the court, and I understand some medical evidence was adduced as well in relation to this mild dementia. Sometimes the court are busy, the court staff that is, they unfortunately are unable to provide the documents to the court, to the judge. However, on the day, I understand that Sandra did provide the letter and this medical evidence to the judge. The judge should have realized that the claimant has capacity issues, and as a result of that, should have adjourned the hearing to allow Sandra to be put as a litigation friend to take to deal with this litigation. The issue we have here is that she wasn't, or the claimant wasn't allowed to be appointed as a litigation friend, nor was the claimant allowed to seek a representation as a result of these capacity issues. So that's the problem I have with the judge in relation to this matter.
So can anyone represent someone in court with those documents?
Well, you have to make an application to the court. I'm not sure whether Sandra did. There's an application on the court website called the N235 application. It's a certificate of suitability of litigation friend. In there, you need to write down reasons in relation to why you wish to be considered as the litigation friend for an individual who is undertaking litigation. If there are serious capacity issues and you have medical evidence to confirm that there is a medical condition that renders the individual incapable of undertaking her litigation, then that must be considered by the judge. At the very least, the hearing or the trial should have been adjourned for the claimant to seek legal representation as a result of this medical condition.
And are there any further steps you can take here? Is there an appeal or a complaints process?
Yes, I mean, without hearing the actual facts of the case, there is an appeals process, and it's usually, if it's at the county court, 21 days from the date of the judgment. I would suggest that legal advice is sought in relation to the paperwork, and an appeal is made on the basis that the judge erred in dealing with the case without allowing the claimant to have a litigation friend or adjourning the trial so that legal representation can be had. The reality is this also, that she was a litigant in person, and I believe that would be supportive of an appeal as well.
Okay, thank you very much for joining us this morning. Appreciate it, Jaffar. Thank you. Let's go back to Sandra. So, Sandra, what's the next step then?
Well, I have asked for a transcript of the trial, which is going to cost another £113, of the hearing, rather. It wasn't a trial. And I'm waiting for that. That should hopefully be with me next week. When I can hear or see exactly what was said, then I will be able to go to appeal, because he has no recollection of exactly what was said, and therefore he can't actually give me the detail, and I can't put in the appeal until I know exactly what was said. But also, as a lay representative, I should have been allowed to say, and I did actually try to say, my solicitor said, if you won't let me represent him, then we should ask for an adjournment. Mm-hmm. And she wouldn't even let me finish that sentence.
I mean, just putting the case to one side, when you're there and you're saying that, and the judge is saying, no, I won't listen to you, that must have been intimidating, angry, frustrating. It was absolutely awful. I came out in tears. So you were trying to talk, and the judge was having none of it. I'm not listening. Leave now.
Yeah. I'm not going to speak to you. And I said, I've written in to say to represent him. You would have had to send a CV. I'm not discussing this with you. Leave the room. And that was, that was it.
And okay, Sandra, I wish you all the best with the appeal, and thank you very much. And of course, listeners, we'll stay with this, and we'll give you updates as and when we have them.